Good evening, everyone. The May 20th, 2026 Arlington County Board of Zoning Appeals hearing is now in session. I am Richard Kaplan, Chair of the Board of Zoning Appeals. The board is made up of 5 citizens appointed by the Circuit Court. Tonight, in addition to myself, we have members in Tamales, Judy Freshman, Carol McCoskry, and Alex Kumana. Also present is the professional staff, including Arlova Vam, Zoning Administrator, Kevin Black, Lindsay Klein, BZA Coordinator, Megan Ryan, BZA Associate Planner, Brett Goldberg, BZA Associate Planner, and Stephen Rissy, Zoning Prims Supervisor. To avoid disruptions, we ask that you please place your mobile devices in silent mode. Before we begin tonight's hearing, I will discuss this board's powers and procedures for tonight's hearing. This board's powers are prescribed in the Code of Virginia and are set out in further detail in the county's zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend regulations set forth in the ordinance. That authority rests solely with the county board. This board does have the authority to do 3 things. First, the BZA can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there is no option in the zoning ordinance to allow such modifications. In order to approve a use permit, the Arlington County zoning ordinance requires that this board find that the proposal will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. In making these findings, the BZA shall consider whether the modifications will promote compatibility of the development with the surrounding neighborhood because of the structure's overall size, footprint, and placement are similar to those of the structures on the property surrounding the lots in question, and whether that modification will help preserve natural landform, historical features, and/or significant trees or foliage. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary and in the public interest, including but not limited to the duration of the use permit. This board does not have the authority to grant use permits to modify requirements for expanded housing option developments. Second, the BZA can grant variances from the specific requirements of the zoning ordinance. When granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that the strict application of the ordinance would unreasonably restrict the utilization of the property, and the need for a variance would not be shared generally by other properties, and such a variance is not contrary to the purposes of the ordinance, or that the strict application of the ordinance would unreasonably restrict the utilization of the property, or that granting the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon at the time of the effective date of the ordinance, or to alleviate a hardship by granting a reasonable modification to a property or improvement thereon requested by or on behalf of a person with a disability. In all variance cases, the property for which the variance is being requested must have been acquired in good faith, and any hardship was not created by the applicant. That the variance granted will not be of substantial detriment to the adjacent properties and nearby properties in the proximity of the geographic area. That the condition or situation of the property concerned is not so general or reoccurring a nature as to make reasonably practicable the adoption of an amendment to the ordinance, that the granting of the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, and that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning or subdivision ordinance. Third, the BZA shall hear and decide appeals of the zoning administrator or from any order, requirement, decision, or determination made by any other administrative officer in the administration or enforcement of Title 15.2, Article 7 of the Code of Virginia. In exercising its powers, the board may reverse, affirm, wholly or in part, or may modify an order, requirement, decision, or determination appealed. The determination of the administrative officer, zoning administrator, shall be presumed correct by this board. The appellant has the burden of proof to rebut the presumption of correctness by a preponderance of the evidence. The board shall consider any applicable ordinance, laws, regulations in making its decision and must base our judgment on whether the administrative officer was correct. The concurring vote of a majority of the membership of this board shall be necessary to reverse any order or determination. Now on to tonight's hybrid hearing. For those who are participating in person, on the front table, you should find a QR code linking to a copy of the application packages, including the staff report for each case before us this evening. For those participating virtually, a copy of each application package can be found on the Arlington County BZA's website. There's also a link in the chat for the application packages. I recommend that if you have not yet seen that report for your case, that you review that report before your case is called. If you are attending virtually and lose connectivity, please reconnect with us by phone. If you are attending via Teams, please keep yourself muted and cameras off until called upon. Turn off the sound on any other devices around you to minimize interference. When called upon to speak, please turn on your camera and unmute yourself by clicking on the microphone icon that is located in the meeting command bar. County staff does not have the ability to unmute you. The meeting chat is active for technical support assistance only. The meeting chat should not be used for discussion, public comments, questions about agenda items, or requests for more information. All public comments must be shared verbally or have been previously provided in writing for the record during the assigned testimony period. This evening, staff will call each case and will provide a brief staff report and recommendation. Next, board members will ask any questions of staff that they may have. Applicants or their representative will be given an opportunity to make comments to support the application or appeal. Next, all speakers for the items will be called. Speakers must fill out a speaker slip, which is either online or is available on the table in the front of the room. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit any cross-examination or direct questioning by others. For tonight's hearing, this board has deemed the following time limits for speakers to be sufficient: 20 minutes for applicants of appeals, 5 minutes for applicants of use permits and variances, 3 minutes for representative of organizations, and 2 minutes for individuals. After the board has gathered all information we need and have discussed the case, we will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Please be respectful of the time allotted. This is a public forum, and tonight's hearing will be recorded and posted on the county's website. All information associated with tonight's hearing, whether spoken or written, is subject to the Freedom of Information Act requirements. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you are welcome to stay for the balance or leave at your convenience. I have no administrative matters to attend to before we call our first case. So I think we are ready to hear our first case, Ms. Klein.
Case number V-12107-26-APP-1, an appeal by Dustin and Evan Sanderson, Taylor Haim, Melissa Fox, Usa Bonsu, and Miriam and Michael Rollin of the zoning administrator's decision to approve expanded housing options EHO permit number ZEHO25-0004 for a lot located in the R6 zoning district on the premises known as 6119 11th Street South, RPC number 11-049-020, Madison Manor. Staff recommends that the board adopt the attached proposed resolution affirming the zoning administrator's decision. Note there is supplemental material for this case that was provided to the BZA after the initial application packet was assembled and printed. And please also note that we have additional speakers who have signed up to speak on this item.
Ms. Klein, how many speakers do we have signed up?
1, 2, 3, 4, 5.
5. And my memory is that there are multiple appellants in this case.
Correct, there are 7.
7 appellants. Do we have a representative of the appellants here, or have they? We normally give appellants 20 minutes, and so it will be up to them to decide how to use that 20 minutes.
Thank you. I will also note that we do have our zoning division head before us to provide a brief presentation from staff.
And is the zoning administrator splitting their time with the person at the subject of the appeal?
I don't think
For fairness, I'm asking.
I'm not going to take anywhere near long as the 20 minutes allotted, but I'm not certain that the property owner is planning to talk. At least I haven't been made aware of that.
And they don't need to.
Yeah.
The appellants have their 20 minutes, and they will amongst them figure out their time. And the county and the property owner have their time as well. Okay. So Ms. Baum, why don't you lead us off?
Sure. So the subject appeal states that the proposed project was incorrectly approved as a semi-detached building. And on the slide, we have an excerpt from the zoning ordinance that defines a semi-detached building as a residential building with 2 attached dwelling units located on 2 lots that share a common wall along the lot line and where each dwelling unit has its own external entrance. The subject EHO request, EHO standing for Expanded Housing Options, as authorized via permit number ZEHO 25-00004, is for a semi-detached residential building. Next slide. As shown on the slide and the drawings provided in the approved permit set, there are 2 attached dwellings on 2 lots that share a common wall, both of which having separate entrances. The approved permit set associated with this request also includes a drawing on the plan sheet labeled proposed conditions. You can go to the next slide, which shows the 2 proposed lots most clearly, including a note that references the fact that a subdivision approval will be required. The appellants believe that because the existing lot has not yet been subdivided, that the EHO permit, which indicates approval of a proposed project on proposed lots, is not allowed. EHO permits do not authorize construction, but instead authorize land use approval for a project that complies with specific standards. The EHO permit in question permits semi-detached dwellings that meet the development criteria. The permit drawings show what characteristics need to be in place for the development to move forward, including the creation of 2 lots. It is not uncommon for a property owner to determine if the land use approval is feasible before proceeding to change their property dimensions via a subdivision. The property owner would not be able to actually construct a semi-detached dwelling until the property is subdivided, and therefore consistent with the physical conditions found in the approved EHO permit drawings. Therefore, the EHO permit approving a semi-detached dwelling is consistent with the zoning ordinance regulations for semi-detached dwellings, and staff recommends that the BZA adopt the resolution affirming the zoning administrator's decision.
Thank you, Ms. Baum.
Sure.
Why don't we hear from the appellant and then we'll entertain board questions. So is the first or speaker for the appellant here?
There are 2 of us listed as the appellants. The rest are supporting neighbors. So thank you for taking the time this evening to hear our appeals. I think that.
I'm sorry, can you state your name?
Oh, yes. My name is Dustin Sanderson. I'm one of the appellants for V1210726. So
Thank you.
I stand before you today because tonight, under fundamentally shifted legal landscape, just yesterday afternoon, Virginia Supreme Court officially agreed to review the missing middle lawsuit. And while the county staff may try to argue that, it is business as usual, until a final ruling is handed down, the Board of Zoning Appeals has a vastly different quasi-judicial responsibility. You are the community's safety valve. When the entire structural foundation of a policy is facing a Supreme Court showdown, proceeding with aggressive borderline approvals on highly constrained lots isn't just bad planning. It is immense legal liability. The profound legal instability at the state level demands that this board apply the absolute highest level of strict scrutiny to the case before you tonight. When you look closely at 6119 11th Street North, the project utterly fails to withstand that scrutiny. It is flawed in its process It is non-compliant in its design. It poses real tangible harms to our neighborhood. First, this project does not follow lawful legal process. The zoning division approved this permit as if the EHO framework were settled in law, and it is not. The trial court already ruled that the county failed to follow proper statutory procedures and failed to study localized infrastructure impacts before passing this policy. By treating a highly contested, procedurally flawed policy as an absolute right, the administrative staff acted prematurely. Furthermore, under Virginia Code 15.2.2307, valid vested rights cannot be born from a flawed permit issued under disputed ordinances. If the Supreme Court invalidates the EHO framework in a few months, allowing the developer to pour concrete tonight creates an avoidable legal minefield for the county and the neighborhood alike. I understand that we're not pouring concrete tonight, right? Second, the project is not truly in compliance with our existing zoning ordinance. An EHO permit is exception to density, but it is not a blanket exemption from the strict text of the R6 district regulations. The approved site plan before you relies on a dangerous strategy of artificial compliance. On paper, the developer has manipulated setback boundaries, structural grades, lot coverage calculations to squeeze in a massive multi-unit footprint on a modest 6,000 square foot lot. This is a paper-only compliance that ignores physical reality. Let's look at this reality, starting with stormwater management. On a standard R6 single-family lot, home is bound by permeable green space that absorbs rainfall. By cramming multi-unit duplex structure in its accompanying mandatory parking onto this tight footprint, the developer is drastically increasing impervious lot coverage. On paper, they might meet the technical threshold, but gravity does not read blueprints. Water runs downhill. We have neighbors from across the street that dealt with this previously. 11th Street North has a very distinct topography, and when you replace absorbing soil with massive building and mass and paved driveways, that stormwater has nowhere to go but into adjacent yards. And while we might have the best practices, the stormwater management facilities that are required by the builders and developers, when you have a certain lot coverage, does it always work? Sometimes it does, sometimes it does not. We're looking into a guaranteed recipe for localized flooding, overloaded gutters, subterranean hydrostatic pressure that will compromise the foundations of neighborhood homes. The trial court noted the county failed to study these exact infrastructure impacts to this, and this site plan is a textbook example of that failure. Furthermore, the artificial compliance creates a profound neighborhood safety issue. When you double or triple the density on a single lot without expanding the physical street, you create a logistical crisis. Multi-unit dwellings mean more delivery trucks, more service vehicles, more resident cars competing for space. Not to mention, we've got a school directly, or there's a back entrance directly across the street that doesn't have enough parking for the teachers. Where do they park? They park on our street. By stretching the mandatory yard setbacks right up to the legal breaking point and shoving the structure directly against neighboring property lines, this plan chokes out sight lines, takes out trees. It creates blind spots for backing vehicles, reduces the clearance needed for emergency response vehicles to navigate the street safely. This isn't just about traffic. It's about whether an ambulance or a fire truck can rapidly access a crisis point on 11th Street North. Finally, we must address the erosion of the neighborhood character. And character is not an abstract aesthetic preference. It's a zoning mandate. The R6 district was legally designed to protect bulk and open space ratios that allow for light, air, and a cohesive canopy. The proposed structure games the system by exploiting technical loopholes on structural overhangs to force a massive looming building that completely violates those ratios. It towers over adjacent properties, casting permanent shadows, stripping away private backyards, and destroying the architectural scale of the block. It's not organic, gentle density. It is disruptive, out-of-scale insertion that degrades the stability and cohesion of an established neighborhood. On a blueprint, you can make anything look like it fits, but in the actual dirt of 11th Street North, it's non-compliant, it's unsafe, and it's in violation of the spirit and letter of our code. Virginia land use law dictates that administrative staff cannot simply use a checkbox approach. They must ensure absolute literal compliance. What happens here is not rigorous enforcement. It was an arbitrary bypass of the code to force a high density project where it physically does not fit. Members of the board, yesterday's Supreme Court announcement changed the calculus. It gave you not only the justification, but the duty to exercise extreme caution. Your role is to look past administrative convenience and defend the integrity of the Arlington County zoning ordinance. The documentation clearly shows the permit was granted in error, rests on a crumbling legal foundation, and I respectfully ask the board to uphold our appeal and enforce the rule of law and reverse this administrative approval of the EHO permit for 6119 11th Street North. Thank you, and I'll give the rest of my time to my counterpart.
Thank you, Mr. Sanderson.
Oh, it's no fun. Okay. Board members, staff, and members of the public. I'm Miriam Rollin, and my husband, Michael Rollin, and I own 6123 North 11th Street, where our adult offspring is the permanent resident. Our house is next door to 6119 North 11th Street. We have joined in this appeal, calling on the board to reverse the decision of the zoning administrator approving the EHO permit for the property, which was improperly issued. I want to note at the outset that I am an attorney and also, since our move down to North Carolina, a voting member of our locality's Board of Adjustment, which hears appeals from our town staff zoning decisions. So I sit where you sit, in a different jurisdiction. Now on to this case. The EHO permit was approved for 2 semi-detached units, but at the time of approval, the criteria in the definition in the Arlington County zoning ordinances, those conditions were not met. The definition of a semi-detached structure is, quote, a residential building with 2 attached dwelling units on 2 lots. There was, at the time of the permit approval, only 1 lot. The fact that there are plans to divide the lot into 2 is irrelevant to an approval of the EHO permit at that time for that single named lot at 6119 North 11th Street. As a proposed permit for a semi-detached structure, it should have been denied, and this board should rectify that error by reversing the permit approval. One additional question for you is the height of each unit being measured based on the average existing grade of each proposed separate lot. If it's going to be 2 lots, then that should be the case. Either it's 2 lots or it's 1 lot. If it's 1 lot, it's not semi-detached. If it's 2 lots, is it meeting the grade requirements in terms of height restrictions for both lots? It doesn't look that way on the plans. The board should address whether the plan is compliant with maximum height rules for each of the 2 plots once divided. Further, just yesterday, as Dustin described, the Virginia Supreme Court agreed to review the erroneous Court of Appeals ruling from last fall. The appeals court had reversed the trial court decision from 2024, finding Arlington's EHO provision to be unlawful and invalid. Given the significant chance now that this entire EHO system could be invalidated, it is unwise for Arlington to continue to process EHO applications, and frankly, unwise for developers to rely on this approval, which could be invalidated by the court's decisions even if structures have been started or even completed. I also commend this board and the county board and every Arlingtonian to read the great report on EHOs issued Friday by Neighbors for Neighborhoods, available on their website. It clearly debunks the myth that the EHO provision has any impact on helping to develop housing for the missing middle, folks with incomes insufficient for housing in Arlington. That is an incredibly valid goal. This is not accomplishing it one iota. Please note also that our meeting packet for this meeting had many, many comments in support of our appeal. 0 comments opposing the appeal. Finally, I want to point out the irony of this particular situation. This developer is proposing to take one of the few more affordable properties in our neighborhood and instead to build a huge building totally out of character with the neighborhood with 2 units, each of which will sell for significantly more than the developer paid for the entire property. So much for helping the missing middle. Thank you so much for your consideration of these very important issues, and I'm happy to answer any questions if you have them.
Thank you. Why don't we do questions of the parties, and then after that we'll have speakers. So, I'm sorry. I thought I was told 2. Maybe I heard that wrong. No, please.
Good evening, dear board. My name is Usa Sananikon. I have been a resident of Madison Manor for the past 40 years. I live in the other house adjacent to 6119 11th Street North, actually the one downward from it, and I am one of the appellants. I've submitted written comments, which are in your reading packet, and the comments describe how the proposed structure, which would be a 3-story duplex next door, would negatively impact my house, my neighbor's house, and our street as a whole. I would just like to say that I fully agree with what my neighbors Dustin and Miriam have said. I respectfully ask the county to reconsider the EHO permit for the property at 6119 11th Street North. At the very least, we ask that whatever new structure is permitted is not 3 stories high, which would just tower over the houses next to it. Thank you very much for listening to our concerns and for considering our appeal. Thank you.
Thank you.
Jay Hamilton with Neighbors for Neighborhoods. I just want to say one thing.
I'm sorry. Are you an appellant?
Yes, I'm with them. I don't think you guys
No,
have.
are you listed as an appellant?
No, I'm not.
No, then this is not the appropriate time
All right, well,
to be speaking.
Check with your lawyers about the Supreme Court decision. before you move
we will do
forward
that.
and
Thank you.
this. You should not make a decision tonight.
Do my colleagues have questions for the county? I thought we would ask questions of the parties and then we'll hear from the speakers. We could all, if you have a strong opinion, we could hear from the speakers as well.
Because I have that, I have issues to ask about.
Go ahead.
I'm looking at, I tried to go through the materials and listen to the testimony for, let's say, substantive issues as to these particular drawings. And so I have a couple of questions on those. There was a comment made about the height measurements. And could you explain, would the height measurement be different for one structure versus 2 structures?
So this is the first time hearing of a challenge to that. I'm not prepared to talk about it because it was not listed as a grounds for appeal. It was not, there was no proof or anything demonstrated that questioned that it was done properly. So I'm not prepared to talk about how it was carried out today.
So you can't say whether it was correctly carried out or not?
In our opinion, it was carried out correctly, and they've not said that it wasn't. But I didn't study it because it wasn't listed
Right, I
as
understand.
something that was found to be incorrect. It wasn't challenged. What was challenged was semi-detached.
All right.
That's the only argument that was provided.
So kind of leaves us with a quandary as to whether it was.
I believe they have the burden of proof to say what was
Okay.
wrong with it.
Okay, that's a good point. The other question is, there was in the staff report, one of the commenters talked about the parking requirement. Can you tell me what as far as surface parking in the lawn area. Can you talk about what the requirement is and whether, in your view, this is compliant?
In my view, it's compliant with all of the requirements. I'd have to look up what the parking requirement is. I don't know that off the top of my head.
So how do we proceed then?
Again, what are they saying is incorrect?
Yeah, I have to look up the specific comment. Okay, I can do that and get back to you on that one. I think that's it for now. There was also discussion about trees and damage to trees in adjoining properties. Would that be a zoning issue or is that a civil matter?
That would be a civil matter.
Okay, that's what I thought. Thank you.
So I'm seeing now subsection 1046A, sorry, 1046B
Right, that was the one they referenced.
is location of parking spaces. Up to 2 surface spaces shall be allowed between the street facing facade and the street. And for corner lots, it's up to 4 with no more than 2 on a single street frontage.
So I read that too, and I looked at the drawings and I wasn't sure how to interpret that because there's driveways in the kind of the lawn area.
So there's a 1-car garage. Sorry. And
Yeah, each of them has a garage and a driveway.
and a driveway. So I don't see more than 2 spaces between the building and the street.
Okay, and so the parking requirement for the development is 2 per unit?
I have to go back and look.
Okay.
It also varies if it's located close to transit. Again, I don't have any of this information available because it wasn't listed as a grounds for appeal. So I can't do a plan review in real time right now.
Okay.
Anything else, Ms. Malice?
That's it for now.
Do my colleagues have anything further for the county?
So it's 1 space per dwelling unit. If it's not nearby transit, it's a half space per dwelling unit if it meets certain location criteria.
So to me, that would suggest this exceeds the
Yes.
requirement.
So in my take on the appellant's main argument in the materials and from the speakers was that this is a chicken versus egg problem. Does the lot division have to come before the EHO permit or can it come after the EHO permit? Is that what's going on here?
I mean, I don't want to speak on their argument, but that seems to be the issue.
And so the county's position is that the EHO permit is not granting any ability to build. It's just moving on to the next phase, in which would include a subdivision. So when does that come in the process? I guess is my question.
At the building permit.
Before, during, or after?
Submission of the building permit would require the subdivision to happen before it's issued.
Okay.
Yeah.
And is that standard process in
Yes.
any building, not just EHOs, in any?
Yes.
Because we see subdivisions on the BZA. Ms. McCuskey?
No, I do think that, and this is one of the difficulties of these matters when they come to us, that the EHO permit, as we see them, is a very preliminary permit, which looks at essentially, could this fit on the property and meet the basic outline of requirements. It doesn't go to the building so often the citizens want to have an understanding of exactly what's going to be built, but it just isn't all decided yet. And then it goes through there's a lot more process to get through to get the right to actually build this development.
Do my colleague, sorry, Mr. Kamana. I was going to move on.
That's a question for the zoning administrator, if that's okay. And this is just a procedural question. Assuming this appeal never happened, right? And there's obviously a court case ongoing at the moment. Assuming this didn't happen and this would continue on to the next stage and the next stage, would this continue on until shovels hit the ground before a determination was made legally, or would it at some point halt and wait for that process to unfold?
So by process, I'm assuming you're talking about the Virginia Supreme Court appeal. Okay, so there's a lot of processes.
Sorry, yeah.
So I'm looking for the statement which we've been authorized to say, which I will read. Let's see. One second. I don't want to get it wrong. Okay. The Virginia Supreme Court has agreed to hear the plaintiff's appeal regarding a developer's right to participate in the case. The underlying merits of the EHO case are not part of this appeal. In its May 19th order, the Virginia Supreme Court did not halt EHO development, so the county will continue to follow the EHO ordinance and review process as adopted by the Arlington County Board in 2023. The county is prepared to comply with any future rulings on this matter.
Thank you, ma'am.
Sure.
Did you have something further?
Are we gonna, it's a time for questions to the applicant?
That was where I was, yep. So do my colleagues have questions for the appellant? Ms.
I have
Munoz.
one. I don't know which of you wants to address this, but on the question of measurement of one structure versus two, if someone would like to come up and provide more detail as to why they think there's an error, I'd be interested in hearing it.
So, again, my name is Dustin Sanderson. I'm one of the appellants listed here. So our understanding is that, the height requirements that are set forth by zoning ordinance, for all intents and purposes, are taken from the average grade of the lot to the highest part of the structure. So, which I believe is 35 feet. Okay, so from average grade to the highest part is 35 feet. What happens now is that where we're looking at challenging this is that by subdividing this lot, you have, and this is where we get into the specific topography of 11th Street North, the entirety of our block is on a pretty heavy slope, right? Which is part of the reason why I was talking about storm runoff, et cetera. So by subdividing the lot now, when you go through the EHO process that wasn't subdivided, which is also part of it, is that you now have a lot that's sloped. So your average grade for the west side of the lot is different than the average grade for your east side of the lot. So is that still correct? Is it still within the 35-foot maximum when you have two new average grades for the lot?
So you're asking me a question?
I think that's the question that's what we're challenging on the height.
I think in order to challenge it, you have to show that they've done this incorrectly.
So under state law, as I said in my opening remarks, the burden of proof is on the appellant to overcome by state law the zoning administrator's presumption of correctness, right? So the Virginia State Legislature in granting this board the authority to hear appeals has granted the zoning administrator a presumption of correctness. So this board under law has to presume that the zoning administrator's position is correct. So you need to overcome that by providing us proof that that decision was incorrect. So simply asking for more information is not going to meet that burden.
So the information that we got through the FOIA Act, which shows the plans that the developer had submitted, has an average grade listed, but it for the entirety of the lot. It does not have an average grade for the subdivided lot because they haven't subdivided it yet. So this is all factual information that hasn't been presented for the zoning for the zoning administration to review. So it needs to be reviewed still.
No, I think the question is, why do you think they've done it incorrectly?
Because the average height is for,
Why do you believe that using the average height for the entire structure is inappropriate?
sure,
If I may, Miriam Rollin for the appellant. So when the materials were submitted, they were submitted as one lot. It was noted it would be divided into two lots. There's no dispute over those facts of the case. So, and I see the nod, I will note that I see the zoning administrator head nodding. There's no dispute that the average grade that is described on all of the paperwork for this proposed property is the average grade for the whole what will become potentially two lots. So having not done the calculations that are needed for what they are proposing, which is two lots, it should have to meet requirements for both lots. But there are no figures.
I think you're
in any of the
speculating.
documents.
The question is,
Yeah.
are they required to do separate measurements for each building?
They should be required to
I
do.
mean, this is a factual
I
question.
think that's a question.
Right, they should be required, each lot should have that 35 feet to the average, because that's what the zoning rules say, that in the lot, you have to have the maximum height and it's measured to the average grade. That's throughout the zoning ordinances, correct?
Can I, I'm sorry,
yeah.
I'm going to interrupt you because I think there's two issues. I think the first issue here is that I don't recall reading this issue in the appeal, as I think the zoning administrator kind of mentioned to us. So that's kind of my first issue with, is that fair to then start questioning the county on this issue that hasn't been briefed? Okay, that's one issue. The second issue is the merits of the argument, right? So I'm looking at the front elevation, and it does appear that the average existing grade is one measurement for both lots. So then the question becomes, well, then which is correct? So on one hand, we have the appellant saying it should be separate by each of the two units, Unit A and Unit B, and we have the zoning administration's position that says I can't answer the question because I'm not prepared to do that.
Okay.
Perhaps.
And so those are kind of my two issues that I'm struggling with. Ms. Fawn.
So there's lots of terms being thrown around, and I just want to read the actual ordinance language. I'm looking at section 316A1, which is the section that specifies how we measure height, and number 1 specifies for our districts, so which is what's relevant here. And it says, the average existing grade is calculated by averaging the existing grade at 4 points at the perimeter of the building that include 2 points each on the front and rear of the building at the points closest to the applicable side lot lines. The vertical distance is the difference between the average existing grade and a single building height determined as described in subsection 316A above, or 2 building heights in the case if there's a dormer. So we're talking about lots and we're talking about points around the building, and it seems like we're confusing the two. So the measurement for height looks at the perimeter of the building, not the lots.
Right, but once it's subdivided into 2 lots, legally, in effect, those are 2 buildings.
Yes.
So then we need to have those measurements applicable to
And-
each building.
And I would say when we're at the point of construction, we will get that information to make sure it complies. It would not be allowed to comply until it continues to meet this, when we have that information, when it's time to actually construct the building and the lots are created.
So the plans as submitted would be approved, but they're not legally meeting requirements in terms of height.
The information provided was sufficient for us to evaluate it at this time, but for construction, we probably will ask for, like, sometimes we need more information. Things change.
Right, but this isn't a change.
I'm sorry, I don't think that going back and forth is
Okay.
helpful. I think the board understands your argument, and now it's for us to decide. Thank you.
Thank
Anything further for the appellants from my colleagues? Let's hear from our speakers. Ms. Graham.
Good evening. My name is Shelley Groman and I live right across the street. This is one of the smallest lots on the street. If you can park 2 cars out in front of it, it would be, it's a very small lot. And if they say it's 6,000 square feet, I really even question that. It's also on a very steep hill. I live towards the bottom of the hill. And when people have done additions and so forth, it's really changed the flow of the water, and it's created a lot of issues to where I've had put sump pumps, a lot of different things that have needed to be. But not only that, there's a school right there. The parking is terrible. A lot of the teachers park on that street. And it would be, a problem with the parking. And then also the height. I think it's a shame that it would be anything other than a single family dwelling. And it sounds like that you guys, like here we are, we're appealing, but it sounds like you've already given approval. So I don't understand, how this is all working. But the fact that it's more than a single family dwelling would be very inconsistent with the neighborhood. They're all single family dwellings there. So that's a real concern. So and it's a shame that they're even tearing down the house. There's one right in the back. They're doing an addition and so forth. But at minimum, a single family dwelling, and it's not towering over the neighborhood and the flooding issues, and is really a concern to me. All right. Thank you very much for hearing my concerns.
Thank you for your comments.
All right.
Ms. Kuhn, who is virtual. And I may have not gotten that name pronounced correctly. Ingrid Kuhn. Okay, we will circle back. Mr. Knott.
Good evening. Thank you to the board for hearing from us this evening. I live at 6111 11th Street North, and I have for 21 years. It's 2 doors down from the subject property, so we are even further down this steep hill you've been hearing all about. I urge the board to reverse this EHO approval in service of the rule of law. First, the ordinance is unambiguous. Section 18.2 defines semi-detached as a building on 2 lots sharing a common wall along the lot line. This approval is for building on 1 lot. Section 10.4 contains no conditional approval mechanism. This was an invention by the staff, and this project fits no other EHO category. It's not a duplex, it's not a townhouse, it's not a multifamily home. The presumption of correctness that you referenced, Mr. Kaplan, is overcome when the decision contradicts the ordinance text, and it does so here. Second, the circuit court ruled the entire EHO unlawful. That is the only court that has ever addressed the merits of this ordinance, and it said it was illegal. The Court of Appeals reversed on procedural grounds only, saying a developer should have been permitted to participate. Never reached the merits. The Virginia Supreme Court has now taken up the case. It makes no sense to jam projects like this through into our neighborhoods while the legal foundation that supports them is under review by the Commonwealth's highest court and has been ruled illegal in the Virginia Circuit Court. If you get to specifics, even the basic measurements break down here. We talked about the average grade measurement. That's a problem with this cart before the horse approach that the staff is taking here. The average grade calculation treats this as one lot, and that's the basis on which the approval was granted. But this building is going to sit on 2 lots. There's a parking lot in front of this house. It's way too big. I haven't heard anything about the calculation of how many cars will actually sit there, and the board should address those on the record. Please reverse. Thank you.
Thank you for your comments. Mr. Linman, virtual. Anyone? No. How about Mr. Barnes? I'm sorry, Miss Barnes. It says Rebecca Barnes. I apologize. I went right to the last name.
My name is Becca Barnes, and I live in Madison Manor at 1105 North Potomac Street, 3 houses away. The missing middle was pitched in Arlington as an affordability issue to many. As my daughter is an elementary school teacher at Escuela Key, who, along with her husband, a mechanic, lives in a rental in Arlington, I was keenly interested in this idea so that they could possibly afford to buy a house one day soon. I live 3 houses away around the corner from this proposed duplex. 16 years ago, we bought this house because of the neighborhood and the schools. All 3 of our now adult children attended Arlington County schools. If this duplex is allowed to move forward, it would drastically change the character of our neighborhood and set a precedent for future EHO permits. The proposed duplex would not be affordable for teachers like my daughter or those of similar income levels. This proposed project benefits only one, the developer, while harming so many others who live in Madison Manor. To the members of the board, if you lived across the street or next door to a proposed dwelling as this, I would respectfully ask how you might feel about this being built. I ask when you vote that you put yourself in the shoes of the Madison Manor neighbors and taxpayers who live next door and across the street from this proposed project, and respectfully request that you grant this appeal and deny the EHO permit.
Thank you, Ms. Barnes. Any further questions, or should we discuss? Ms. Freshman?
Are the 2 virtuals listed in the, are they attending?
Ms. Freshman, I'm not seeing them on the attendee list. There's a couple phone numbers. So if they are Ms. Kuhn or Mr. Linneman, please unmute your microphones at this time if you'd like to speak.
Thank you, Mr. Goldberg.
Thank you.
Chair Kaplan?
Hold on. I'm sorry, can you hear me?
Who is this?
My name is Kate Flynn. I raised my hand only because my neighbor, Tina Coiney, is on her way down to my house because she couldn't connect at her own home. So she was one of your listed speakers. And
I'm sorry. And what was that name?
Tina Coiney, Ingrid Coiney is her legal first name.
Okay. Well, we will. Thank
Sorry,
you.
Go ahead.
Yeah, no, so I mean, we're going to continue on, and if she shows up and we're still discussing the matter, then we can address it.
Thank you.
Thank you. I appreciate you letting us know.
Oh, sir, I think she may be here now. Would that be all right?
That would be, yes, that would be all right.
Okay, great. Thank you. Let's see. Oh, I got rid of my camera, but please. I told them you were here and they're ready to listen to what you have to say. Oh,
Okay.
Can you hear her all right?
Yes,
Great.
we can hear you.
Okay.
Hey, good evening, everybody. I am a 74-year resident of Madison Manor, and I appreciate your having this open field to get our views. And it's just such a special little neighborhood with what is now called a starter home, but it has been, you know, a wonderful environment of a small subdivision to support and to enjoy. And the fact that these larger houses are coming in to displace us at some point, and I have a sense of reality about that too. But the fact that we need teachers and we need EMTs and we need nurses to be able to come into this close-in area of Arlington to help our students and help the people that still live in these starter houses that are so well built with brick and are always being replaced by man-made materials, so that there are so many reasons to keep the scale of the new housing reasonable, not to mention my other source of support for this smaller house and or the mortgages that they will have to pay is that I noticed all over Arlington there are hundreds and hundreds of apartments being built, condos, and all those people coming into this county are contributing their own tax source for us to support our own people who want to enrich the quality of life of this county. And I thank you for your time and your patience to hear me.
Thank you for your comments. I believe we are now at closing the public comment period and discussion with the board.
Excuse me, if I could just, I'm sorry, if I could just.
Please, Mr. Black.
Just expanding on the zoning administrator's point earlier in terms of the issue that was just brought up regarding the height of the building. The statute clearly says for an appeal, just to make note to the BZA, that 15.22311A does state that they have to, when they file their notice of appeal, state the grounds for that appeal, and that wasn't a ground that was stated. So just to mention that again. Thank you.
Thank you.
Final comments? Are you ready for final
Yeah,
comments?
discussion, comment. Yes.
So I guess I want to respond to the comment that the BZA is a safety valve. It is true that we are, but our authority is very limited in terms of what we can actually offer. And I think if you all have done your homework and looked at some of the other EHO cases that we've heard, you will know that we can only rule on whether a regulation has been followed. We cannot rule on whether we think the EHO ordinance is a good idea, whether they've taken in all the other factors like infrastructure, trees, parking. Those were all things that were discussed when the county board adopted the ordinance. Our role is very limited to whether the zoning administrator correctly issued a permit based on the zoning regulation itself. So regardless of whether you or I think that this is a good idea in general, it is what is in place right now. And until the courts reverse it or change it, that is what we are compelled to go by. I know some question has been introduced about height. I believe that, as the zoning administrator said, if there really is a question about that, it'll be worked out in the building permit process, and that it will be correctly applied at that time. It is true that, we have in our rulings allowed the zoning administrator some flexibility in what elements of the plans are disclosed right at the beginning versus in later stages, like trees. Sometimes the trees aren't all drawn in, and the zoning administrator can make sure that they're complying before the project goes further. But in my view, the zoning administrator has followed the regulation. And I know that's disappointing to you, but I think that I need to rule in favor of the zoning administrator.
Thank you, Ms. Mellis. Ms. McCoskey.
Yeah, I have some of the same points. We are faced with the ordinance as it was enacted. It may be changed that it's not appropriate. The courts, we don't know what they will do in the end. The Supreme Court's decision will be a limited issue of whether parties get to participate. But I think I understand there's a lot of frustration with this ordinance about whether it meets the purpose of providing missing middle housing and whether there's, going to be sufficient protection. I think it is important to keep in mind that what can be built on a site is the same ultimately as a big single family home on the site. It's the height requirements are the same, the setbacks and everything like that is the same. It doesn't make it easier, but that is the fact that, that how a single family house could potentially be built as well. And I agree that although, there's the question about the height, but height is always determined for buildings, I guess, near the end of when they are built. And does the structure meet the height requirement to get the final approval? So I agree with Ms. Malice that I can't find a clear error under the ordinance as it exists today.
Thank you, Ms. McCoskey. Anything further from my colleagues? I unfortunately will echo my colleagues' sentiments. I know one of the speakers rhetorically asked, if this were being built next to one of us, how would we feel? And I have a lot of empathy for a lot of the comments, that we have in driving by this lot, right? It's a really cute neighborhood. I don't think I saw a house that was that 35 feet tall, right? Unfortunately, though, this case is not before us as a lot of the rest of the cases we have tonight, where this is not a use permit where we get to judge compatibility. This is not a variance where we get to find hardship and a bunch of other criteria, right? This board has no latitude to even consider the negative effects of EHO projects. If we assume everything that everyone here has said tonight, with drainage and parking and all of that, that's not beyond our purview. And, I feel for everyone here because I wouldn't want this house next to me, but I don't get to make that judgment. This board does not get to second guess the county board's decision to do EHO projects. That's the sole purview of the county board. I think that Mr. Black with the county attorney's office is correct that even the height issue is not properly before this board tonight because it wasn't briefed to the county, and that's not really fair to hold the county to every argument that can come before them in real time. And so the big issue is whether this lot has to be split at the early EHO permit or at the building permit phase. And in every other case that we have done, the lots that's handled at the building permit phase unless a variance is needed, and there's no indication that a variance is needed in order to split this lot to make this project work. So that's where I'm at, and I imagine that's the three of our colleagues. So if someone would like to make a motion.
I I move that the Board of Zoning Appeals uphold the decision of the zoning administrator and adopt the resolution to that effect in the staff report.
Second.
A motion by Ms. McCoskey affirming the zoning administrator as recommended in the staff report, seconded by Ms. Malice. Is there any further discussion? Does anyone else want to be heard? Hearing none, I will call the roll. Ms. Malice?
Aye.
Ms. Freshman?
Aye.
Ms. McCoskey?
Aye.
Mr. Kumana?
Aye.
Chair votes aye. Motion for affirmation passes 5-0. I just want to echo that I want to thank everyone for being heard tonight for whatever that's worth for participating in the process. Ms. Klein, I believe we have a full agenda now. So I would like to thank everyone for their patience for that long hearing as the room empties out. I imagine most of us are virtual then. Can you call the case? Next case?
Case number V-12108-26-UP-1, a use permit request by Brian Dillon, the applicant, on behalf of Adam Cohen and Megan Miller to permit a street setback of 19.2 feet to the front porch, 19.2 feet to the porch eave, instead of 21 feet to the front porch and 19.5 feet to the porch eave as required, from South Dinwiddie Street right-of-way regarding a wraparound front porch to an existing one-family detached dwelling in the R6 zoning district on the premises known as 2216 South Dinwiddie Street in Claremont. And staff recommends that the board adopt the attached proposed resolution approving the use permit request, subject to the listed conditions.
Thank you, Ms. Klein. Do my colleagues have questions for staff? Hearing none, is the applicant with us?
Yep.
Mr.
Hello.
Cohen. You are the owner.
Correct.
Would you like to speak to your application?
Sure. Good evening and thank you to the board and the staff for your time tonight. My name is Adam Cohen and my wife and I are requesting approval of a modest encroachment related to a wraparound front porch at our home on South Dinwiddie Street. Specifically, we're requesting a modest encroachment of 1.8 feet with the porch setback of 19.2 feet rather than the standard 21 feet. We appreciate the staff's thorough review and the recommendation for approval. As outlined in the staff report, the proposed porch is consistent with the surrounding neighborhood and comparable to a number of nearby porches already existing in the area, including several with setbacks closer to 17 feet. In addition, the proposal does not create any adverse impacts. As noted in the staff report, there are no identified impacts to health or safety, no detriment to the neighboring properties, and no impact to the trees, landform, or environment features. We also work closely with our neighbors throughout the process, and we're grateful to receive support from all adjacent neighbors, neighbors behind us, and neighbors across the street. We appreciate the board's consideration and respectfully request approval of the application. Thank you.
Thank you for your application. Do my colleagues have questions for the applicant?
Just
Malice.
just a brief one. You're wanting to make your porch 6 feet?
Correct.
Okay.
6 feet seems to be the magic number.
So you would probably love it if you didn't have to come to BZA to get that approval.
I would love that, yes. But
We would love that too. Could you actually make that a mission to get that regulation changed?
It took me like a year to get here, so yeah, I will support that. We'll just
No, we need you to initiate it.
Okay. I'll take a look into it.
Contact your board.
Or run for a board spot.
Or run for
office,
board,
right.
run for office. This is something that we struggle with a lot. I will note that Claremont in particular favors wraparound porches. There are many in Claremont, because I live not far from there and walk through that neighborhood often. So in terms of compatibility, it certainly fits in with the style of the neighborhood.
And to that point, a lot of slopes, hilly areas, be backyards that aren't kind of usable. I used to live near there too, so yeah.
Would someone like to make a motion? Or I didn't mean to cut you off if you wanted to say something.
Mr. Chairman,
Ms. Malice.
I move that the Board of Zoning Appeals adopt the attached proposed resolution approving use permit V-12108-26-UP-1, subject to the conditions listed.
A motion for approval, subject to the conditions listed as advertised by Ms. Malice, seconded by Ms. Freshman. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice,
Aye.
Ms. Freshman,
Aye.
Ms. McCoskey,
No.
Mr. Kumana.
Aye.
Chair votes aye. Motion for passage passes 4-1.
And I just,
Ms. McCoskey.
yeah, I just wanted to make a comment and explain that I'm going to continue to vote no on these 6-foot porches instead of 4-foot, just because that is, we had a discussion. This is part of the purpose of the zoning ordinance, is to set aside light and air, and the ordinance is consistently sets a limit of 4 feet for that, but I am happy you got your porch.
Thank you. Ms. McCoskey. You won't hold it against the rest of us. Ms. Klein, can you call the next item on the agenda, please?
Yes, case number V-12109-26-UP-1, a use permit request by Dean Kretzinger, on behalf of Heidi and Larry Dillard, the owners, to permit a right side setback of 4.1 feet to the building eave instead of 5 feet to the building eave as required, to permit a street setback of 13.3 feet to the building wall, 11.9 feet to the building eave instead of 25 feet to the building wall, 21 feet to the building eave as required along 6th Street North, and to permit a street setback of 13.8 feet to the areaway and 13.7 feet to the deck instead of 21 feet to the areaway and deck as required along 6th Street North regarding a new 2-story rear addition, deck, areaway, and a 2nd-story addition above the existing 1st story to an existing single-family dwelling on a corner lot in the R6 zoning district on the premises known as 525 North Kenmore Street, Ashton Heights. Staff recommends that the board adopt the attached proposed resolution partially granting and partially denying the use permit request with conditions granting approval of the 2nd-story eaves above the existing 1st story and denying the requested street setback reductions from 6th Street North. 2 alternative resolutions have been provided to the BZA see fit to approve the use permit request as advertised with the conditions or to deny the use permit request.
Thank you, Ms. Klein. Ms. Freshman.
So the portion which is denial is along 6th Street, right? And the proposed addition appears to be measure exactly the same, 13.3 as the existing. So I assume they decide that even though the existing would not be consistent, the fact that they've designed the addition to run aligned the same way is the issue on 6th Street?
Yeah, so while the footprints and setbacks that I identified in the report might be compatible by themselves, the overall kind of bulk size and massing of their addition wasn't consistent, and it was larger than a lot of the BZA approvals I was finding and noted in the staff report. And yeah, so the BZA generally just hasn't seen expansions as large as this addition based on what we were able to identify that have street setbacks as close as what they're requesting.
And what would be acceptable, given that the existing isn't acceptable, but if there were addition?
I think there have to be some kind of balance between the setback potentially and the footprint, but that might be up to the applicant to.
Mr. Chairman.
Miss Malice.
So what I see is that the addition is actually set closer to the street, closer to 6th Street than the main walls of the existing house. In other words, the existing house has a bump out, I think, for a window, and they've lined it up with that bump out and actually exceeds that bump out. So it's actually wider than the existing house. It's kind of offset a little bit, but it actually is closer to the street than the existing house. And I do agree with the massing question. It creates a pretty big wall going down the street.
Significant, not just expanding the setbacks, also going up 3 stories.
Right.
Just for, I'm translating. I know you know that.
Right. It's, it's creating a big wall along 6th Street.
It's McCoskey.
Yeah, I just want to add to that because this is a corner lot, to me, it's a little, it's quite different from, or it is different from if this was an interior lot where it was just going to be a little bit of incursion. To me, I think this kind of addition on a corner lot should be pulled back from the street frontages more if possible. In fact, they could still do a fairly big one because they have 10 more feet to go back. But I feel like this is almost, I mean, this creates a circumstance where it's trying to take advantage of the corner lot and make it like an interior lot. And so that concerns me along with the size of the addition.
Let's hear from the applicant. Who is in person? Sorry? Who is just in person?
Good evening. My name's Dean Kretzner. I'm the architect and the applicant for 525 North Kenmore Street. I'd like to just take a couple of minutes to highlight some of the key design issues of the proposal. At first, I'd like to concur with BZA staffing in their assessment that our proposed dwelling may be compatible with the surrounding area. Our proposal has gone to great lengths to fit in with and be compatible with the neighboring structures by every measurable zoning metric. A few examples of that would be, as noted in the staff report, our building footprint is 2,054 square feet. That is less than what's permitted on a very similar, is less than what's permitted, and is actually very similar to the corner lot right across the street. It's the adjacent corner lot. Also, our proposed building footprint is significantly less than the neighboring homes and nearby interior lots by as much as 700 square feet. So we meet the zoning metric in both those cases. Another example is the design of our addition is the existing house, which is purposely held as low as possible. You'll note that over the existing portion, we only are 30 feet tall, roughly, and we're allowed to go up to 35 feet. So what we've done purposely is try to keep the front of the house, the existing structure of the house, low and personable, and not extend it up to the full extreme of the allowable height. Additionally, our proposal adopts many of the architectural features found in the existing home, going to great lengths to even preserve the existing front porch. We do this in order to maintain the character of the original home while continuing the scale of other houses in the neighborhood. And finally, our roughly 38% lot coverage is substantially lower than the 48% we're allowed. This allows for more light and air and open space, and is another way our proposal is compatible with the surrounding neighborhood. Zoning conditions were not the only aspect of our design that we tried to be a good neighbor to. The new addition is set back 8.4 feet from the nearest adjoining neighbor, the nearest neighbor to the side, not the street side, obviously, and thereby meeting or exceeding the zoning setback requirements. Additionally, to increase privacy to the same neighbor, we've moved the existing areaway that was on that side, it's between the two spaces, over to the new addition. Hence, the request for the areaway setback use permit is a direct result of our design decision to try to increase our neighbor's privacy. An even larger influence on the footprint, the overall footprint of the addition, is the provision of a bedroom on the first floor that allows the owners to age in place. This was always one of the appealing aspects of the existing home for Heidi and Larry, since they knew by having a first floor bedroom, they'd be able to age in place. This is their forever home. They don't want to move. And it's one of the existing features of the home that really appealed to them at the very beginning. This respect of the existing home, while planning for the future and allowing the owners the ability to live forever in the home, provides ownership continuity to the neighborhood, which is known to benefit the entire community. And speaking of the community, you'll note the neighbors' letters of support. As further evidence, we have considerate and cooperative design. The letters of support include both adjoining neighbors, as well as the Ashland Heights Community Board President. And I'd be remiss not to acknowledge the BZA staff concerned about that our proposal may not be compatible with previously approved setback modifications. I will say from the outset, we've been very intentional about shaping this addition so that it respects the street, the scale of the neighborhood, and the neighborhood's character. And we've accomplished this by our decision to reduce the height of the house, our decision to use architecturally historic features that are consistent with both the existing home and the neighborhood, our decision to increase the setback distance and location of the addition and areaway to our nearest neighbor, who would be mostly impacted by the addition. And finally, we've accomplished this by our decision to substantially underutilize the allowable lot coverage and the building footprint. These elements, taken together, provide meaningful steps to ensure the home size and character is compatible with the neighborhood. Remember that in architecture, size is but a number. Know how one scopes that size through the use of height limitations, architectural features can greatly affect the feel in building regardless of its square footage. The elements we've listed and included in our design should alleviate the concerns from staff and this board regarding the compatibility with previously approved setback modifications. In closing, our design demonstrates a deliberate effort to remain harmonious with the surrounding neighborhood while also addressing the practical needs of the homeowners. The reduced height, minimized footprint, increased side yard setbacks, and preservation of key architectural elements collectively ensure that the proposed addition enhances rather than overwhelms the existing streetscape. We believe this proposal reflects a thoughtful, responsible, and a neighborhood-focused approach to improving Kenmore Street, and it aligns with the intent and spirit of the zoning ordinance.
Thank you.
I would just like to say that the house does not extend beyond where the existing house does currently. I don't know if that's a misreading of the plan, but
well, I think the point is that the entire house does not extend to 13.3 setback, that only a bump out does. And so
right.
we're taking that 13.3 to the extreme by extending that all the way up.
Right.
I think that was Ms. Malice's point.
Right, and the 13.3.
So it doesn't, we're looking at the main house being 15.5, not 13.3.
Okay, the 13.3 bump out does continue all the way up.
Can you, on your materials, can you point me to the elevation of that side of the street? I'm having trouble figuring out which elevation goes to that side of the street.
You can kind of see it actually on the front 3D as well.
Yeah, I don't want the 3D. I want the side.
Okay,
I want the
side
elevation.
elevation is on sheet 2.1, I think. Let me just see. Hold on. It's actually 2.4.
Top or bottom?
Top.
Top. Okay.
That's the north elevation, left side. So that bump out is that two-story structure. That's on the existing portion of the house. Kind of to the right side.
Oh, I'm looking at a different 2.4.
Oh, I hope not.
It's on the screen. Okay, so it's the top. It's the top one. I'm looking at. Okay.
Yeah.
So I guess my question then, looking at the plat, right? I don't see bump outs on the plat. I just see a flat line. Oh, I see. Okay, I see.
Yeah, the intent is never for the addition to go beyond any point of the.
So I looked at the catacorder across the street that you cited.
Mm-hmm.
I don't think it is as comparable as you say, because actually, it's probably, I don't know what's an addition or what's not an addition, but the catacorner 3412 6th Street North, part of the house is set back, right? So there's not a full 3-story front facade.
Right, I wasn't
along the street.
I'm sorry, I was referencing the house across the street. It's listed in the staff report as being 1,940 square feet, and ours is 2,050 for a footprint.
And so if it's directly across the street, it's a 1-story house, not
correct,
not 3-story. So the problem is we're trying to do compatibility here, and we're looking at not just what massing. We're not just looking at square footage. We're looking at the whole totality, and I think that's the problem. At least that's the problem I'm having. I won't speak for my colleagues, but I'm having trouble with the compatibility. Do my, I hijacked that. Do my colleagues have anything for this applicant?
I did want to say also that the homeowners are online, I believe, are they? And they would like to.
No, we give 5 minutes to the applicant and their representative, and so you have used that time.
Okay, so they don't get any time.
No.
Oh, I was under the
And you
understanding
were-
they would
and I-
get, they would get additional time.
And I allowed you significant leeway over your time as well. And we have another dozen cases before us tonight.
Okay.
Do my colleagues have anything further for this applicant? Discussion with the board.
I'm inclined to support the staff recommendation.
Could I ask a quick question? Is that allowed?
No.
Okay, all right.
I'm having trouble figuring out what a question would help here. So, yeah. Do you want to try a motion? And we'll see where we are. Because we have a quiet board tonight. Other than myself, of course.
Mr. Chairman,
Ms. Freshman.
I approached this case thinking that I didn't have any issues with it, but actually I have to say that seeing the rendering makes it seem hugely out of proportion to me. I probably will support the motion because that's an opinion, a personal preference. But I think that what's been created is essentially a solid rectangle that doesn't, I mean, it has a couple of different roof lines, but it reads as one solid building without much in the way of sculpting and stuff. So that being said, I could support the motion that may be coming, but it's not common for me to see a rendering like that actually gives me pause.
Thank you,
Mr. Chairman.
Thank you, Ms. Freshman. Ms. Malice.
I move that the Board of Zoning Appeals adopt the attached proposed resolution, partly granting and partly denying the use permit V-12109-26-UP-1, granting approval of the second story eaves above the existing first story and denying the requested street setback from the 6th Street North.
Second.
A motion by Ms. Freshman, Ms. Malice. She threw me off. Partial approval and partial denial, seconded by Ms. Freshman. Is there any further discussion? I just want to ask Ms. Malice if that's what we intend to do without plans. You threw me off there. Right, so if we're doing a partial approval and partial denial, what are we? I need some clarification on, I guess, on what that is. So does that mean we can go, we're allowing 3 stories up? I don't know what we're approving.
That's a good question.
I think it means what the
And maybe Ms.
resolution
Klein
says.
can answer that.
Would you like me to provide clarification on what the ordinance, what the staff recommendation text
please.
says? Yes.
Yes, please.
It says, adopt the proposed resolution, partially granting and partially denying the use permit, granting approval of the second story eaves above the existing first story, and denying the requested street setback reductions from 6th Street North.
So mainly we're approving eaves.
Yes, because Article 16 of the zoning ordinance allows for a second story addition above a first
Got you.
story.
Thank you. That's the part I was missing. And I guess, no, I mean, I guess before we vote, and I might hijack this again, is that even something the applicant is interested in?
What do you mean?
Well,
Is this an approval, right? If we might be granting an approval that the applicant isn't asking for.
I think the motion speaks for itself.
Yeah, I think,
Okay.
I think it does. I mean, but I think to make it 100% clear, that means we're not approving the big addition.
Not approving the big addition, but
Right.
we are
Just
approving the applicant could,
Second story on
right,
it.
the applicant can add a
Yeah.
second or third story.
And staff can provide some guidance on
Yeah, I'm just,
which way to go for the portion which is not being approved.
I just feel like we're remiss if the applicant doesn't weigh in on that. Because maybe they would like a deferral for another opportunity and not have to refile for a new variance. But I don't know if my colleagues want to entertain that.
I'm
Could be thinking-
willing to entertain that. I think we should explain to the applicant what that
Right.
means and how that would work.
Have we voted?
We have not. We have an
No.
open motion.
I'm inclined to not and continue as we're planning to. We kind of just talked about this, earlier, and like I don't want to add more work or more deliverables, and then we kind of arrive at the same place. Or like you mentioned, we make it explicitly clear what a deferral entails.
Right. I just, because if the applicant wants to come back before us, then they're going to pay several $1,000s in fees. That's
Right, and
that's all.
this
Try to
is,
minimize that.
this is not the applicant we're speaking with right now in person, right? So keeping that in mind too. I just want to be mindful of the things we were talking about.
So it does not sound like you are walking away with an approval as advertised tonight.
Right.
It
Understood.
It sounds like you might be able to walk away with an eve approval and ability to go up, but not back.
But not back.
Is that, I don't know if you've discussed this with your client, or if that's something you're interested in.
Well, it would be on us to try to, I think you said continuance, was that?
Yes, what we have sometimes done is we defer the matter for 2 months to allow an applicant to revise their application. You could get, because I think we haven't had lots of discussion of this among the members, but you could potentially, people could give you their individual thoughts about what might be better to come back. You could work with staff to try to achieve that, with understanding that staff can't design it or tell you what's going to be approved, but they can try to help interpret what's been said. So that means you don't have to come in with a separate new application if you come back in 2 months. And I think it's 2 months. Staff needs to tell us if that's,
Minimum.
yeah, minimum.
I
So
will just note at this time that would mean there's no meeting in, it would be July,
it would be July.
and then there's no meeting in August, so.
So,
Oh, I'm sorry.
yeah. So if that's what you can speak on what you prefer to do.
Yeah, I would think that would actually, from both our perspective and the board's perspective, might be actually the better way to go, because what that allows us to do is come back with essentially the approval, the understanding that there's an approval for the eaves. And then we come back with a redesign of the addition that would hopefully also meet your approval.
And just to
And gets rid of some of the ambiguity that I think you were saying or asking for clarification on what was the approval actually for, and it was for the eaves of the.
Yeah, no, that was,
Yeah.
I got it, right.
Right.
And so now I know that we're, I was not 100%
Perfect,
sure what we were
perfect.
voting on, right? And so I kind of stopped this because I'm not sure that is that something you'd be, if you get that approval tonight, is that something you'd be interested in, or you want to try and rework it with, again, the caveat
rather
here
be-
is, I'm sorry, I don't know where my colleagues are in what would or wouldn't be approved. This is a very big project with massing and setbacks. There's a lot going on here. And so it is possible that might be the best you get. We don't know. I don't know, right? We don't make promises.
Yeah, no, understood. But it would seem to be in all of our interest to actually do the deferral and come back, knowing that the eaves are, essentially okay, but that the massing of the addition needs to be reworked.
There is a motion.
There's
on
an
the
open
floor.
motion. So would you like to amend your motion or withdraw your motion or speak to it?
I'm trying to think of what the proper procedure is. I guess a motion that's been seconded, I guess if the seconder agrees to a withdrawal, I can withdraw it.
Or we can vote on it and see how it goes.
Well, that's true. We could vote on it. And then.
Why don't we just vote
and
on it?
then- Well, but then if we
Alternative,
conclude it.
alternatively, you can propose a new motion
You
and
can-
the most.
You can do a substitute motion. Somebody can make a substitute motion.
I would like to make a substitute motion to defer to our July scheduled hearing. Is there a second?
Second.
A substitute motion made by the chair, seconded by Ms. McCoskey to defer to our July scheduled hearing date. Is there any further discussion? I will call the roll. Ms. Malice,
Aye.
Ms. Freshman,
Aye.
Ms. McCoskey,
Aye.
Mr. Kumana.
Nay.
Chair votes aye. Motion to defer passes 4-1.
Thank you very much.
So we're not done.
Oh, sorry.
We're not done.
Now the substitute motion becomes the
Oh.
main motion.
Okay. So now, do I just call a vote on the main motion?
Okay.
And now it's,
Now we have to vote on the
The main
main
motion.
motion.
yes, now it's
Which
a
is
vote
the-
on the main motion.
Okay, so now we have substituted the motion. Do I need do we just vote?
Yes.
I will call the roll on the main motion for deferral until June. July, thank you. Ms. Malice,
Aye.
Ms. Freshman,
Aye.
Ms. McCoskey,
Aye.
Mr. Kumana.
No.
Chair votes aye. Motion for deferral passes 4-1. Thank you.
Thank you.
Can you call the next item, please? Ms. McCoskey. Sorry.
Case number V-12110-26-UP-1, a use permit request by David and Emily Leichtman, the owners to permit a left side setback of 1 foot to the accessory structure instead of 8 feet to the accessory structure as required, and to permit a rear setback of 15 feet to the accessory structure and instead of 25 feet to the accessory structure as required regarding a new accessory structure, a pergola and a swing to an existing one-family detached dwelling in the R6 zoning district on the premises known as 600 North Harrison Street, Bluemont. Note there is supplemental material for this case that was provided to the BZA after the initial application packet was assembled and printed, and is included as comment forms, emails, and text messages in support of the project.
Do my colleagues have questions for staff? Ms. McCoskey?
I do. This is a very small thing, but it requires a use permit because it's attached to the ground.
It is qualified as an accessory structure. Yes, it meets the definition for accessory structure, and therefore accessory structures, unless otherwise permitted some type of encroachment from the setbacks, it has to meet the setback.
Okay, because a garage of this size wouldn't need this.
A garage falls under a separate accessory. It's an accessory building, and accessory buildings have different setback requirements than accessory structures. An accessory building is a type of accessory structure, but does not fall under this provision or that same provision.
Okay.
Anything further for staff?
Yeah, I had a question that may be for the applicant. I'm just trying to, if I'm not mistaken, on the tax map, it shows a structure besides the house, but I don't see the structure on the plat. I just want to confirm that. Do you see that? Yeah, there's see that right there in the corner, there's a structure.
Yes, hello, I'm the applicant, Emily Leichtman, and that structure you're referring to is a shed.
Is a shed, but it's not on your plat.
I don't know why it's not on the plat.
Thank you.
Would you like to speak to your application?
I just want to say thank you for the opportunity to be part of this conversation. And I also want to share how greatly we appreciate the staff time that has been devoted to our application. Staff have recommended support of our pergola project. And so I really don't have any other comments about that, but I'm happy to answer any other questions you have.
Thank you. Would someone like to make a motion here?
Need to see it. I move the Board of Zoning Appeals adopt the attached proposed resolution granting use permit V-12110-26-UP1, subject to the conditions listed.
Second.
A motion by Ms. Freshman for approval as advertised, seconded by Ms. McCoskey. Is there any further discussion? I'll just say, I'm sorry you had to come here for such a small project, but I love the renderings. I love the pictures. You did a great job.
Thank you. And I don't want to take any more of your time, but we're also confused about why we had to come for this. So
We can have that discussion
maybe,
later.
yes,
We
that's
are
for another
too.
time. Thank you so much.
Ms. Malice.
Yeah, I was just going to say that another justification is, you do have a very odd shaped lot. And so you're kind of limited as to, where you can actually place things. And I suppose it's outside chance your shed isn't on the plat because it's not on a foundation.
It is not on a foundation.
So maybe that's why they didn't record it. Anyway, I'm happy to support the motion.
Thank you.
Ms. Freshman.
Aye.
Ms. McCoskey.
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion for swing passes 5-0. Good luck.
Yeah.
Like the color of your room.
Ms. Klein, can you please call 5 and 6 together?
Case number V-12111-26-UP-1, a use permit request by Jacob Browning on behalf of Rodney and Tina Blanton, the owners, to permit a rear setback of 13.9 feet to the rear porch, 13.2 feet to the porch eaves instead of 21 feet to the porch and 19.5 feet to the porch eaves as required, and to permit a separation of 2.2 feet between the porch and the accessory building wall, 1.6 feet from the porch eaves instead of 8 feet as required, and to permit a rear setback of 15.5 feet to the accessory structure, built-in grill, instead of 25 feet to the accessory structure as required, regarding an after-the-fact rear porch and deck addition, built-in grill, and accessory building to an existing one-family detached dwelling in the R8 zoning district on the premises known as 6300 29th Street, North Williamsburg. And note there is supplemental material for this case that was provided by to the BZA after initial application packet was assembled and printed, including an updated disclosure statement and a letter in support from a neighbor. And staff recommends that the board adopt the attached proposed resolution denying the use permit request. An alternative resolution has been provided should the BZA see fit to approve the use permit request as advertised with the conditions. And case number V-12111-26-VA-1, a variance request by Jacob Browning on behalf of Rodney and Tina Blanton, the owners, to permit a total lot coverage of 43.2% instead of 38% as required, regarding an after-the-fact rear porch and deck addition, accessory structure, built-in grill, and accessory building to an existing one-family detached dwelling in the R8 zoning district on the premises known as 6300 29th Street, North Williamsburg. And the same supplemental materials provided for this case as the previous mentioned. Staff recommends that the board adopt the attached proposed resolution denying the variance request. An alternative resolution has been provided to the BZA see fit to approve the application as advertised, subject to conditions.
Thank you, Ms. Klein. When we get cases with both a use permit and a variance, we typically deal with the variance issue first and then go to the use permit because that's the threshold matter. We can't grant the use permit without the variance. And we're going to, as everyone sees, we're going to try and deal with the two together, and then we'll make two separate motions to wrap up. Do my colleagues have questions for staff? Is the applicant with us?
Yes.
Would you like to speak to your applications?
That'd be great, please.
Go ahead.
Okay,
And
well,
please
first off,
introduce yourself. Yep.
Yep, sure. I am Jacob Browning. I'm the architect. I'm representing the homeowners. Thank you very much for your time. I appreciate it very much. So first off, I'm going to start on touching base on the actual lot itself, and then I'll get into some specific items noted in the report, and then I'll summarize it up, and I'll try to keep this short. So first and foremost, I would like to note, this is right out of the report, the lot is zoned R8, one family dwelling district. The zoning district permits one family detached dwelling on lots that contain at least 8,000 square feet of lot area and measure at least 70 feet. In terms of their average width, I would like to note the subject property has a non-conforming lot area, 6,440 square feet, but we have a conforming average lot width of approximately 72 feet. So the way those proportions result is that with the minimum lot size and that lot width of 70 feet, we can get a depth of 114 feet. But with our lot size, with a 72-foot width, we're prohibited to about 89. So we're about 25 feet shallower than the minimum required lot of this size. So that that puts a few prohibitions on our lot that doesn't allow us to build what might otherwise be allowable. So one of the things we're looking for is we're pursuing approval for a lot coverage that would be compliant if this lot was the minimum allowable lot size. And we are applying under the grounds that the granting of this variance does alleviate a hardship due to a physical condition relating to the property or improvements thereon, which existed upon the effective date of the zoning ordinance. So to say again, the improvements that we are proposing that have already occurred would result in a conforming lot coverage of 34.8% had this been a properly sized lot. Let's see, in the next item, have the property owner shown that the property was acquired in good faith and that any hardship was not created by the applicant. We are disagreeing with the things listed here. We said the hardship was not created by the applicant as we did not create this non-conforming site. This wasn't a subdivision that we pursued or anything like that. And then granting the variance will not be of substantial detriment to the adjacent property and nearby properties in proximity in that geographical area. So we have discussed this with multiple other property owners in the area, I believe 7, who've all expressed that they do not have any issue with this project. Moving on to item 3, the condition or situation of the property is not so general or recurring as to make reasonably practicable or formulate a regulation which can be adopted as an amendment to the ordinance. And so, again, we're showing that this lot is 25 feet more shallow than the minimum allowable lot in this zoning. So all of that is really taken out of the backyard in something of this proportion, since we have a width that is above the minimum, but a total area that is 20% beneath the minimum required. So we're looking for a little bit of lenience in terms of that backyard because it is 25 feet shallower than is typically allowable in a house of this zone. And I would like to note as well that we are looking for a variance of the rear setback as well as the proximity to an accessory structure. There are grounds in this neighborhood that these have already occurred, notably 6230 29th Street does break the required rear yard setback and is I believe legally non-conforming. And then 6215 29th Street does break the required distance between accessory structure to the house. So we are looking for something that already does exist and already has been approved in the local area. Let's see. So, and then just to summarize where we're coming from, I would like to note that the homeowners did trust the wrong industry professional. All these items and all these proposed designs have already been built, unfortunately. He then built a series of structures that would have been compliant had this lot been appropriately sized with the proper spacing. And this has, again, it's been built and paid for. If anyone has been done a disservice, it is the homeowners. Any order to demolish the structure would result in a large financial loss for the clients and also a substandard backyard for this neighborhood. The result would be a further disservice to the homeowners as well to the neighborhood, as no neighbors have expressed any issue with this project. So what we are pursuing is approval for the lot coverage that would be compliant if this lot was the minimum allowable size. We're pursuing approval for a setback variance that is already existing over at 6230 29th Street. And we are pursuing approval for the proximity to an accessory structure that is already existing over at 6215 29th Street. That's all we have. Thank you very much for your time.
Thank you for your application. Do my colleagues have questions for the applicant?
I have a comment.
Sure.
Your argument about your lot size would hold more water if your lot wasn't the actual same size as every other interior lot on that block. So this is not the only underside. All of the interior lots, as far as I can see on the tax map, are the exact same dimension, as well as the lots behind you. So if we were to be persuaded by your argument, we would have to allow everybody on this block the same latitude as you're requesting.
Okay, and I will say, in some ways, we are looking for some leniency that has been approved to some of our neighbors. For example, the rear yard setback over at 6230 and also the distance between accessory structures over at 6215.
But that's different than a variance, which requires more massing, which lets you have more square footage of building on your lot. And I think the problem that this board has is that we don't have the authority under state law to give you what you're asking for because you don't meet the actual standards that were given to this board by the legislature of Virginia. Undersized lots are pretty common in Arlington. And one of the findings this board needs to make is that the condition or situation of the property is not so general or reoccurring as to make reasonably practicable to formulate a regulation which can be adopted as an amendment to the ordinance. And so if the county board thought that this was a problem, they could ordain an ordinance to fix it. Or you could go to the county board and petition them to fix it. So that I kind of have that, I'm having that problem here. And that's also evidenced by Ms. Malice's point that every lot on this block is similarly situated, but I'm taking that one step in that, there are a lot of 20% undersized lots in Arlington County.
Yeah, it's not unique.
And if some of them were perhaps granted some relief with a use permit, they were done before.
We don't know.
We don't know, but 99% of the cases before us come before the actual construction.
All the lots behind you are actually even smaller. So it does.
And so I have empathy for the situation of where this applicant is at now. But that is not a criteria that we get to take into, in my view, that is not a criteria we get to take into consideration in granting variances. Granting use permits, we can assess compatibility with your surrounding lots. That is not, we have to first grant a variance in order to get to the use permit.
Mr. Chairman,
Ms. Freshman.
I have several concerns, but as always, something that's built and comes to us after the fact with no permits is, for me, the biggest challenge. I hear the applicant's representative saying, well, these would be okay if it was a full-size lot. Well, but it's not a full-size lot. So in addition to it being too large, that is the additions, they were built without permits. And I think at some point, there's a line in the sand.
Can I respond to that?
No, it's the public portion of this is closed. We're discussing with the board.
Sure, thank you.
Anything further? Or would someone like to take action? Before you make your motion, I'll just echo in my view, built with or without a permit, I don't hold that against the applicant. If this were coming to us prior to approval, my opinion wouldn't change, right? So whether it was built after the fact or before the fact, I'm still looking at it in my view the same way. Ms. McCoskey.
Yeah, I'll just state quickly that I agree, and I think the biggest problem is that an ordinance could be enacted to fix this if the county board so choose. So I move that the Board of Zoning Appeals adopt the attached proposed resolution denying the variance V12111-26-VA-1.
Second.
A motion by Ms. McCoskey for denial as advertised, seconded by Ms. Freshman. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. McCoskey.
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion for denial passes 5-0. Would you like to make the use permit?
Sure. I move that the Board of Zoning Appeals adopt the attached proposed resolution denying the use permit V-12111-26-UP-1.
Second.
A motion for V-12-111-26-VA-1 for the use permit made by Ms. McCoskey, seconded by Ms. Freshman. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. McCoskey.
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion for denial passes 5-0. Can you please call the next use permit?
Yes. Case number V-12112-26-UP-1, a use permit request by Parveen Zahida, the owner, to permit a left side setback of 1.1 feet to the building wall, 0.5 feet to the building eaves, instead of 8 feet to the building wall, 5 feet to the building eaves as required, regarding an after-the-fact addition to an existing one-family detached dwelling in the R5 zoning district on the premises known as 700 North Barton Street, Lyon Park. Note there is supplemental material for this case that was provided to BZA after initial application packet was assembled and printed, and that is a letter in support from the neighbor at 703 North Barton Street.
Thank you, Ms. Klein.
Sorry, I never said that staff recommends that the board adopt the attached proposed resolution denying the use permit request. An alternative resolution has been provided to the BZA see fit to approve the use permit request as advertised with conditions.
Thank you, Ms. Klein. Do my colleagues have questions for staff on this item? We'll call you up in a second. Give 1 second. No questions for staff. Okay. Would you like to speak to your application?
My name is
Yes, how are you?
Hi, my name is Parveen, and I live 700 North Barton Street. But the basement stair, water was going too much in my basement, so I tried to put some shed on, so water don't go on the stair down. So I make it. I wasn't know that I supposed to get the permit from the county, So when the guy came and somebody complained them or something, so I come in the county and I tell them what I should do. So they told me to make the pictures and stuff and show you guys, okay, I'm okay.
Thank you. Ms. Malice.
What is your address? Where do you live?
700 North Barton Street.
700. Okay. Thank you.
I don't have no idea I should get permit, I just put a small shed on it and put some extra stuff in there. But they say it's too much close to my wall, it's supposed to be separate, the shed, But I make it already. I spend a lot of money, So what I should do now? But I try to.
Do any further questions for the applicant?
I have
Ms. McCaskey.
This is, I don't know, for staff. What's that enclosure made out of it? Is it just a metal piece over that, or is it a building wall that's built in there?
It's difficult to tell what the material is, but it is upon inspection from our inspector that went out there from the Inspection Services Division. It is a building wall, meets the requirement for building wall, but I will note that this information wasn't communicated to the applicant as well, that any subsequent building permit that is obtained for any approval that would happen tonight would require that due to the distance of the building wall from the side property line, fire separation, safety would need to be met. And so additional thickness in about 1/8 of an inch could be required.
So it would require a rebuild.
In order to meet building code requirements, it would need to likely have modifications made to it, yes, from what its current state is as shown on screen.
What is it used for?
I just put some extra stuff, my grandkids' playpen and stuff like these, toys and things, put in there.
It's more than just a covering to a stairwell,
Yeah, just because
right?
too much.
It looks significantly big. So I'm looking.
Is there a stairwell in there?
Yes, it was the applicant's submitted statement indicated that it was originally an areaway down to the basement that was collecting water, and so cover was initially added to it, and then it appears it is larger than, of course, just the area covering the areaway itself now.
Right. It's much bigger than covering the stairwell.
Ms. Klein, I'm having just a hard time visualizing this, but on the March 9th, 2025 pictures, there's clearly something there, right? There's a shed, there's some structure that is clearly roughly a quarter of the size of the current one. And then we go to the December 8th one, And we don't have, okay, the exhibit 3, the December 8th one, it's clearly significantly bigger, right? And there's a bump out over it. Do we know if the one that existed in March 9th, was that on any plat? Does the county know about that?
The county does not have records of any permits issued for that work either. It appears from our review, it was constructed sometime between, I'm going to widen the range because I can't remember off the top of my head, 2005 and 2017, I would say. And there are no records for permits issued for that work during that time.
Because even in 2011, there was something there.
Yes.
But then we go back to 2009 and there's nothing there.
Okay, there, thank you. There we go.
Yeah.
Yes, it's whatever the photos are there. So it was between 2009 and 2011. It was constructed.
Right. So what's before us is a pretty significant addition that encroaches significantly into the setback. What's not before us is something to deal with water over a stairwell, in my view.
So can I just ask the applicant, were there 2 things built, a small one and then later a bigger one?
No, the other one, when we bought the house 1991, there was a small shed on top of that. That was very old house, I think 1965, somebody make it, when we bought it. So there was a small shed and it was leaking too much down and trying to be falling down. So we just moved that structure and put this thing, to stop the water, and plus some extra things I put it in there.
But you
Go ahead.
but you made it extra large. It's larger than just covering the areaway.
Because I wasn't know that the guy who was fixing that, he says, okay, you don't need to take a permit. Now I'm calling him where you are, you put a lot of money and he's not picking up phone. I don't know where is he, So, but he's the one who fixed it for me this. So, but I'm the one who pay for that.
So you understand that you can't keep it, even if we were to approve it, you can't keep it the way it is. Because it's too, the inspector says that you have to improve this structure in order to make it safe for a fire.
For a fire? No, everything is okay. All my neighbors sign it. There is nothing.
No, it's not your neighbors. It's the county building inspector.
Yeah.
Says it has to be redone so that there's a firewall there to protect from fires.
Because you're so close to the neighbors.
Too close to the property line.
That's the problem.
So you're going to have to spend money. You're either going to have to take it down, or you're going to have to spend more money to bring it up to code.
Cover it, what? Cover it, what area I cover it?
For fire safety.
Building code.
Building code.
You're gonna, so even if we approve this, you're gonna have to pull a permit with the building inspection division. I think building inspector, I could be getting the terms wrong. And they're gonna be inspecting the electrical. They're gonna be inspecting the walls, the structure. Are the walls thick enough for fire code? All sorts of stuff. Electrical, plumbing, if there's anything in there. So even if we approve this today, there's going to be a significant expense. I think what Ms. Ellis is saying.
The electrical, plumbing, everything is very separate. We got the hole and make it out. See, in that there is a thing, we make it out, that thing, the pipe is nothing inside. All the electric things is separate outside from.
But the inspector has already said that there needs to be a firewall.
Yeah, it's already, we make it. When he talked to me, I put one pipe from there and I make it out, the guy,
You did what?
Where is the electric, where's my wash dryer machine and
Yeah,
all the
no, he's
smoke
saying
come out?
not electricity. We're saying firewall, that the whole wall of the building is going to have to be redone to make it safe for a fire.
Where is the fire things are, I know what you're talking about. When we dry the dry cleaners and all the smoke come out.
No.
We make separate.
No.
If I can explain,
Okay.
the state has requirements for how every building needs to be built. And they require that exterior walls, such as the walls of this building, need to be a certain thickness in order to slow down the ability for fire to burn through it really fast. So these walls, as inspected by the inspector, are not thick enough to meet that requirement. So no matter what happens, they would not pass that check or inspection They don't meet the code for that. So no matter what, they would have to be redone in order to be safe.
So you want me to take it out, everything broke it down? That's what you want me to?
I think that may be what needs to happen.
But you need to talk to the building code people because it's a different set of rules and get them to tell you exactly what needs to be done. But there's going to have to be changes, definitely, because the building code people have looked at it already and said it
Hey, how's it
doesn't
going?
protect against
I
the
just wanted
fire.
to say, yeah, I'm her son, by the way. My name is Naveed. I'm here listening to the call. Just wanted to say hello.
Oh, this is my son. Dear.
Yeah. So I was listening to everything you guys were saying. I think what we can do is maybe find somebody to get an estimate, a quote before we decide to break it down, see how much it would cost to build that firewall. Just because she puts an ample amount of money into this, and it was basically done. So there was a lot of water flooding happening, going down to the basement. So that's what she was trying to prevent. And I do it. She did make it a little bit bigger, or bigger than what we was expected. And we were under the impression that I think if it was under a certain size, then it would have been okay. But then we found out after the fact that it was only if it was not connected. If it was not connected to the building, we would have been fine. And that was our mistake. And is that okay if we can maybe try to find out how much it would cost to build this firewall, as opposed to like tearing it down, because we paid all these variances fees and all these other things, and it's quite costly. And maybe we can find somebody to build the firewall.
So I think what Ms. Malice's point is that no matter what we decide tonight, there's going to be a significant expense. And there's two are really independent of each other. It's really not in this board's purview to compare the cost of one versus the cost of the other. We're looking at, is this compatible with the neighborhood? Are the criteria of a use permit met here? And this is, you've seen the staff's recommendation is denial, because staff does not believe that this fits into the character of the neighborhood and meets the other requirements for a use permit.
I am inclined to support the staff recommendation to deny. I think you have options. You're either going to shore up, you're going to have to rebuild something. And if it's just a cover on the areaway, that probably doesn't require anything from us.
I would agree with that. And I would just say that we can't here determine where the wall should be or what it should be made of, if there's a wall there at all. The point is that it's now with the building inspectors, and there will be follow-up. And so I think the staff's recommendation is appropriate. And now it moves to another part of the county system to work with the applicants and to tell them what they're doing. Because for one thing, it's only 1 feet from the property line.
Right.
So right off the bat, that's an issue. But it's not for us
we
to
own the
redesign
adjacent-
it or explain it.
Yep. Pardon me. I just want to say we own the adjacent property also, and our cousins live in the other address, 700 and 704. And then we own the 2507 North Pershing Drive. So these three houses all connected are our properties.
But they're separate properties, and each of them has their own requirements, which will be explained to you. So I support.
Yeah. Does it? Mhm. No, the reason I was asking is, does it matter that this is just it's like a storage shed? It's not like anybody
No.
lives there or it's any of that thing. It's just like something to put stuff in.
It looks like it has a foundation, which makes it a structure.
Are you making a motion?
All right. Okay, so I guess what we'll try to do is, maybe talk to somebody and see, how much it would, cost on our end to, if it's more beneficial for us to break it, or if it's in our favor to build a firewall and keep it. Because she spent a lot of money on this, and it wasn't intentional for this to happen in the first place. It was basically like the county person, when the basement flooded, they basically told her, you can build something, to prevent the flooding. And in her mind, that was like permission, kind of, and I know that's not the case. But
it sounds like your recourse is with that person who did that, and so that's not really before us tonight.
So
no, somebody from the county, I don't think can. Mm-hmm.
So I'm going to make a motion to deny this use permit, which means that whatever you decide, you can't build it this close to the property line, that you're going to have to build it, come up with something that meets the zoning ordinance.
If I may, I am the one that helped the homeowners submit the application, and the stairwell is already within the setback. The only thing is that because it isn't, if it's not covered, then there is not an issue with zoning. But as soon as there is a cover on it, because it's within the 8 feet setback, it will still be a zoning issue. So it doesn't matter what she builds, we would still need like some kind of variance to have anything there.
Can we call a question?
I think I'd like to make a motion.
Yeah,
Please.
I mean, future projects are not before us tonight, so there's not, I don't know that we could be.
Chair Kaplan, for the record, I'm sorry, could you please ask the person that just spoke to provide us with their name for the
Yeah,
record?
who just spoke?
2 people.
My name is Denise Tussar.
Okay, thank you.
And my name is Naveed Mughal.
Thank you.
Mr. Chairman,
Ms. Malice.
I move that the Board of Zoning Appeals adopt the attached proposed resolution denying use permit V-12112-26-UP-1.
Second.
A motion for denial is advertised made by Ms. Malice, seconded by Ms. Freshman. Is there any further discussion?
How long do we have to, take this down and all that? If you were asking, I'm not sure if that was a question.
That's not a
directed towards
question. That's not a question that this board even could answer if we wanted to. You would have to contact the inspection division. I don't know how that, we don't know how that works.
Is there an active case against this right now?
Yes.
Okay, so it's with code enforcement right now. So you would have to talk to code enforcement.
We don't work for the county, so we can't answer any of these questions.
Okay. All right.
I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. McCoskey.
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion for denial passes 5-0.
Good luck.
Buck.
Yeah.
Okay.
Yes.
Going on?
Yes. Ms. Klein, can you?
Yes. Case
Window
number V-12113-26-VA-3, a variance requested by Heather Beatty on behalf of Carlin Place Condominiums, the owner, to permit a street setback of 38 feet from the center line of Cherry Hill Road to a window well instead of 46 feet from the center line of Cherry Hill Road, as required regarding the replacement of a window well in the RA8-18 and RA6-15 zoning districts on the premises known as 4371 Cherry Hill Road, Waverly Hills. Staff recommends that the board adopt the attached proposed resolution approving the variance request with conditions.
Thank you, Ms. Klein. Do we have questions for staff?
This is a variance because of a use permit. This district has no use permit option. And we have no neighbor input, correct?
That's correct.
Is the applicant with us?
Heather, my colleague, is not able to be here. My name is Kevin Sinsel. I'm with LCS Property Services.
Thank you.
Which
Would
is
you
the
like to speak
contractor.
to the application?
I'm here mainly just to help answer any questions that the board might have.
Thank you. Does my colleagues have questions for the applicant?
So this is a replacement of a window well, is that correct?
That is correct.
A variance to replace an existing window well.
Yep.
Okay. I guess that's a hardship.
Yep.
I don't know.
Yeah, what is the standard?
I mean, can the county board grant make an ordinance? I don't know.
Well, yeah, there's existing.
Right.
Yeah, there's
No,
existing units down
It
there.
seems
that
like this
won't
should
be
not be
able to-
before us.
Right.
Right. I mean, that's right. I don't think this should be before us, right? This needs.
Let's have a motion.
I move that the Board of Zoning Appeals adopt the attached proposed resolution granting variance V-12113 26-VA-3, subject to the conditions listed.
Second.
Motion by Ms. McCoskey, seconded by Ms. Freshman. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. McCoskey.
Aye.
Mr. Kumana.
Aye.
I'm going to vote no, just to have a protest vote that this should be not before us and the county board should do something about this to waste this applicant's money and time. So
Thank you very much. I appreciate it.
Motion passes 4-1. I don't begrudge you your window well.
Thank you.
Goodbye. Ms. Klein, is that it? Was there one more?
One more.
One more.
Case number V-12114-26-UP-2, a use permit request by Cook Brothers on behalf of Alexander and Alejandro Fernandez Pons, the owners, to permit a left side setback of 9 feet to the building wall instead of 10 feet to the building wall is required, to permit a right side setback of 5.6 feet to the building wall, 5.2 feet to the building eave instead of 10 feet to the building wall, 6 feet to the building eave as required, and to permit a total aggregate side yard width of 14.6 feet instead of 18 feet as required, and to permit a street setback of 13.3 feet to the building wall, 12.5 feet to the building eave instead of 25 feet to the building wall, 21 feet to the building eave as required with regard to 1- and 2-story rear additions, a front foyer, a rear porch addition, and a rear deck addition to the existing single-family detached dwelling in the R6 zoning district on the premises known as 716 24th Street South, Aurora Highlands. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions, and note there is supplemental material for this case that was provided to the BZA after the initial application packet was assembled and printed, and that is a neighborhood outreach petition in support with signatures from 6 nearby neighbors.
Thank you, Ms. Klein. Do my colleagues have questions for staff?
Just confirming that this, we're looking at this because they didn't pull it within 1 year.
Correct.
And there's no change to the previous approval.
Correct.
Which I remember with fondness.
I'm trying to remember.
I'm happy to just move it right along.
Let the applicant speak and then we'll do that.
Yes.
Well, considering he sat here the entire night.
You know, I saw him here and I said, boy, you're going to be here a while.
Have you enjoyed your evening?
Sorry.
Um,
More than we have.
What did we get wrong tonight?
I'm Steve and Steve Tinter, General Manager, Cook Brothers, and I certainly did choose the wrong evening to not have dinner before the meeting. But anyway, as you pointed out, yes, this is the same application that was brought before you, and that was determined by this board to meet the criteria for use permit in March 2025. My apologies for having to come before you again with this. It was a misinterpretation of what that 1 year application deadline. We actually had a permit number issued to us within that, at that 1 year deadline, but we were advised by staff that since the permit was not under review, they were considering the application null and void. So it's kind of was an interpretation issue. I've been doing this for 33 years, and that's the first time that's come up. Our intention always was to do this project within that year. The owners who actually are on the virtual call, they couldn't make it for some health issues tonight, but they're both government employees, and they, at the time of the first approval, there was some uncertainty surrounding in government employment, and they decided they were going to put the job off, and then I just cut it too close, and like I said, didn't understand what the deadline was. So anyway, we appreciate the board's reconsideration of this. Like I said, nothing has changed. Yeah, since you determined that it met the criteria a year ago, and I promise that if granted tonight again, there will not be a third time as a charm this time next year.
Maybe we should add that as a condition.
If I may interrupt for 1 second, because Steve failed in doing what he should have done first, which was to thank the commissioner for remembering this fondly, A. And B, I'm glad that we got his promise that he wasn't going to screw this up again, because he'll have to pay for it if there's a third time. Listen, as you guys know, the world caught fire last year. I'm not going to say why, but it did. And I wish I could be there with y'all in person, because I actually did enjoy my time there last year, but things aren't easy.
You
And
don't have to butter us up that much.
no, I sit on a dais all day too, so I know what you guys go through. But it was fun. But things I like being on the other end, believe it or not. It's we just need to get this done because things aren't getting any easier on our end. And I do appreciate your time tonight, so I'm just gonna cut it short and say thank you.
Can I, for the record, please ask if that was Alexander or Alejandro just speaking?
It was Alexander, and we
Thank
both
you.
look the same and are the same age and have the same name, so.
Thank you.
Make a motion.
Ms. McCusker.
Motion.
I move that the Board of Zoning Appeals adopt the attached proposed resolution granting use permit V 1211426 UP-2, subject to the conditions listed.
Second.
Tie goes to Ms. Freshman. Motion made by Ms. McCoskey, seconded by Ms. Freshman for approval as advertised. Is there any further discussion? I think I voted against this the last time. I'm just going to say
No,
that.
you did not.
No.
I did.
No, it was 5-0.
Was it? I have the minutes up. I was looking for it, but I didn't have good enough time. I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. McCoskey.
Aye.
Mr. Kumana.
Aye.
Chair votes aye. I now feel much more comfortable. Motion passes 5-0. I guess we'll see you back here in a year.
Thank you.
Congratulations.
Now, watch the setbacks. We don't want you to be back here. Can you go over an inch?
Absolutely. We never, knock on wood, we've never had that happen.
Thank you, everyone.
Have a good one.
I move approval of the April 15, 2026 minutes.
A motion by Ms. Freshman for approval of April minutes, seconded by Ms. Malice. Any further discussion? Hearing none, I will call the roll. Ms. Malice, Ms. Freshman,
Aye.
Ms. McCoskey,
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion passes 5-0.
Having